student chairperson of the Moot Court Committee Internals at the Institute of Law, Nirma University, and it is my pride, honor, and privilege to welcome all of you to the finals of the 11th edition of the National Moot Court Competition 2022. Today, we shall be having the two teams who have qualified through grueling sessions in their preliminary and semi-final rounds argue on the problem present in front of all of us. We are ecstatic to have such a brilliant bench adjudicating the rounds today. Without any further delay, I would like to begin with the rounds. I would like to invite both. Before we do begin with the rounds, I would like to invite the appellants in this case to kindly provide us with their time division. I hope my instruction was audible to the appellants. You may unmute yourself and give us your time distribution if that would be convenient.
Right, sorry, I wasn't able to unmute myself. So speaker 1 for the appellant will be speaking for a total time of 20 minutes with 2 minutes for rebuttal, while speaker 2 will also be speaking for a total time of 20 minutes.
All right, that would be great. And if the respondents could follow suit and also give us their time division.
So for speaker 1, 23 minutes, for speaker 2, 24 minutes, and 3 minutes for sorry buttals.
24 minutes, correct?
Yes. And 3 minutes for sorry buttals.
Sorry buttals. All right. With that, thank you. I hope the marshals have taken note of the same. We shall be beginning with the rounds. All the best to both teams. And once again, thank you everyone for joining us today.
Your Lordship, Your Ladyship, the counsel for the appellants solicits permission to proceed.
Yes, please.
Much obliged. Your Lordship, Your Ladyship, may it please the court. I am the counsel for the appellants T003A, and I, along with my co-speaker, will be representing the appellants that are Patel Data, Rish Investment Strategies, and Aditya Singh Rajput in the present matter. I will be speaking for a total time of 20 minutes, while my co-speaker will also be speaking for a total time of 20 minutes. I, being the first speaker, will be covering the issues pertaining to the alleged anti-competitive conduct of Patel Data and Rish Investment Strategies respectively, while my co-speaker will be covering the third and fourth issue respectively. In order for your lordships to better place our arguments, I would like to provide a vantage point of the dispute. The respondents in the present case have accused the appellants of engaging in anti-competitive behavior, particularly the violation of Section 3 and 4 of the Competition Act by not providing the essential index data and providing investment consultancy services at cheap rates. Further, non-bailable warrants were issued for Mr. Aditya Singh Rajput. I will be contesting these arguments by proving that Patel Data and Rish Investment Strategies did not engage in anti-competitive behavior. Now, moving to my first argument, that Patel Data did not violate Section 3 of the Act. Vertical agreements between enterprises operating at different stages of production that are anti-competitive in nature are prohibited by Section 3, subclause 4 of the Act. A test for the violation of Section 3, subclause 4 was laid out in the case of automobiles dealers Hathras by the CCI. The test had 3 relevant parameters. First, there must be an agreement between the parties. Second, the agreement must be anti-competitive under Section 3, subclause 4 of the Act. And third, the agreement must cause an appreciable adverse effect on competition in the market. Applying the test to the facts of the present scenario, the appellants submit 2 arguments. First, the appellants did not have an agreement. And second, in any case, alternatively, the agreement was not anti-competitive under Section 3, subclause 4 of the Act. Moving to the first subprong, that the appellants, that are Patel Data and Rich Investments, did not have an agreement. An agreement under Section 2B of the Act is defined as an understanding or arrangement between two or more enterprises. The term agreement must be interpreted widely to include an arrangement. However, such course of conduct must be backed by an exchange of communication to prove that the conduct induced the other party to act in a certain way. Now, the test for an arrangement between parties was established in the case of British Basic Slag and reaffirmed in Hindustan Times Limited in the Indian paradigm. This test has three essential elements. First, there must be a conduct on behalf of one party that induces the other party to conduct itself in a certain way. Second, there must exist an exchange of communication in this regard. And third, such exchange must induce the other party to act in a certain way. In the present case, although Rich Investments did announce their venture into floating trading services, there was no conduct on behalf of either Patel Data or Rich Investments that has induced the other to act in a certain way. Here, there is no form of exchange of communication between the parties regarding the same. It is pertinent to note that there was a fixed pre-decided agenda for the shareholder meeting on the 28th of February. The agenda of the respondents' proposal was in addition to the pre-decided agenda, which was rejected unanimously by 75% majority of the shareholders, apart from Abhay Singh and Aditya Singh Rajput. In light of this, as the second element of the test is not fulfilled, the appellants humbly submit that there was no exchange of views between the parties that induced Patel Data to reject the proposal, and thus there was no arrangement between the parties. This brings me to the second prong of my argument, that in any case, alternatively, the appellant submits that the agreement was not anti-competitive under Section 3, Subclause 4, Subclause D of the Act. This provision of the Act prohibits any agreement that amounts to the refusal of deal with, however, it has a necessary ingredient of the intent of restricting or eliminating competition in the market. The Council would like to draw your Lordship's attention to the case of United States versus Colgate, wherein it was held that such practices pertaining to the refusal to deal should only be discouraged under the circumstances wherein the same is done to maintain or create a monopoly. Further, an individual refusal to deal would not amount to the violation of competition law. The Attorney General's National Committee report opined that an individual enterprise's discretion pertaining to refusal to deal alone should not be viewed as illegitimate, as it can lead to development and progress. The refusal to deal can stem from various factors, including unfavorable experiences or even personal dislike. Furthermore, under the circumstances wherein there's an objective justification for the same, then the agreement would not fall under the ambit of the refusal to deal. Applying the principles to the fact of the present case, the appellant has rejected, although the appellant has rejected the respondent's proposal, the same cannot be held as anti-competitive. The particular rationale for this is that there is the missing ingredient of the intent of restricting competition or maintaining a monopoly in the market. The appellant has simply exercised its individual discretion to not deal with another firm. Further, Patel Data offered services to Rich Investment Strategies, and providing the same to 3 other stockbroking entities would have curtailed the growth of Rich Investment Strategies. Additionally, Patel Data was not the only working data aggregator in the market. Apart from Patel Data, it is pertinent to note that there were 2 to 3 other firms apart from the ones in Yashgar that were providing indexed aggregated data. Therefore, the appellants humbly submit that the agreement does not fall under the ambit of refusal to deal and therefore does not violate Section 3 of the Act. Moving to the next prong of my argument, in any case, alternatively, even if there were to be an agreement, it does not satisfy the third prong of the test. That is, there must be an appreciable adverse effect on the competition in the market. In the judgment of Oscar versus Media Print, the essential aspects of refusal to deal that would cause an appreciable adverse effect on the competition in the market were listed down. First, access must be indispensable for the rivals to compete. Second, failing to access must pose a risk of eliminating all competition in the market. And last, there must be no objective justification of the same.
Counsel, just one thing. I mean, you are quoting US or EU case laws on whether this will cause an AEC in the market or not. We have section 19 subclause 3, which deals with conditions by way of which the commission can actually determine whether a particular agreement will cause an AEC or not. So why don't you deal with that first, and then we can see whether any reliance on EU or US case laws would be applicable.
Indeed, Your Lordship, that is indeed a valid consideration. Now, to ascertain, as Your Lordship rightly mentioned, that to ascertain whether there was an AEEC, the CCI must take into account the various guiding principles that are mentioned under Section 19, Subclause 3 of the Act. These include, among others, the elimination of competition, the foreclosure of competition, the accrual of benefits to consumers, and the improvement in production, distribution, or competition in general to the market. Now, I would like to bring to Your Lordship's notice that Rish Investment Strategies is a relatively new firm in the market that provides access to the entire catalog of financial news, stock predictions, and investment consultancies, and accordingly requires promotion and awareness amongst the user base. Therefore, by providing the data, by refusing to provide the data to the respondents, the same is done in order for the individual Rish investment strategies to meet competitions in the market. And furthermore, as I mentioned, that an important element for the same is that there must be an objective justification of the same. The same was reaffirmed in the Indian paradigm in the case of, in two cases, namely Noida Software Technology Park versus Media Pro Enterprises, and secondly, Noida Software Technology versus Star India Private Limited and others. Now, in view of the above, we humbly submit that neither was the product refused was indispensable for the three broking entities. The product refused was not indispensable for the three broking entities that are Narayan Broking, Tiwari Financials, and Sarkar Stock Partners. And further, indispensability means that the access must be extremely essential, without which this could be fatal to the other competitors in the market. Here, admittedly, the refusal here by Patel Data did not make the activities impossible or uneconomical to the respondents, as there were 2 to 3 other data aggregators in the market that were providing the same aggregated data to the respondents, that could have provided the same aggregated data to the respondents. And therefore, as there were other service providers too in the market, it cannot reasonably prove to be fatally uneconomic for the entities. And thus the requirement of being fatally indispensable is missing. If Your Lordships do not have any further questions, I would like to move to the next prong of my arguments, that the appellants have not violated Section 4 of the Act.
I just have one question. Neha, so you want to go ahead?
No, please, ma'am, go ahead.
Yeah, so my question was, what do you think is the relationship between Patel Data and the other company, which was the name of the company? Just a second. Rish Investment Strategies. What is the relationship, first of all, and how do you think it covers Section 3, subsection 4 of the Act, that is, if there was an agreement, what are the different stages or levels which you have identified, even before getting into the fact that whether or not the agreement causes an AEC?
Your Lordship, I would like to bring your attention to the fact that Aditya Singh Rajput, who is the founder of Irish Investment Strategies, holds a 40% shareholdership in the company. And therefore, although he does have an influential say in the operations of Patel Data, there is no agreement between the parties that has per se that has restricted Patel Data to refuse or to refuse to deal with other enterprises in form of any form of exclusive.
So my question is more
agreement.
fundamental, not the ownership relationship, but it's the verticality of the relationship, in the sense how are Patel Data and risk investment strategies connected vertically, because 3 subsection 4 deals with vertical agreements.
Indeed, Your Ladyship, they do have. So I would like to draw Your Lordship's attention to the fact that Irish Investment Strategies does obtain index aggregated data from Patel Data.
Okay, so it's in the same production chain, or in the distribution chain, or in the storage, sale, price, trade in goods, or provision of services? What is the chain of engagement?
Indeed, Your Lordship, in Your Ladyship, Patel Data supplies Irish Investment Strategies with aggregated index data.
Okay, so they're in the same production chain. That's what you're trying to imply?
Indeed, Your Lordship, they're in the same production chain, however, at different stages of the production chain.
Right. Yeah. So I think my colleague had another question. So
just one point. So in terms of section 19.3, once you establish that there is an agreement between the two enterprises at a different level of production chain, now how is your conduct actually benefiting the consumer? Like if you the last 3 factors, how would you justify that? I mean, you are refusing to provide a certain service to a downstream player, right? Now, how will you prove that? I mean, this is benefiting the consumer.
Indeed, Your Lordship, that is a valid consideration. The appellants for the counsel for the appellants submit that this would be beneficial for the welfare of the consumers. Now, for decades, the 3 stockbroking entities that are Narayan, Sarkar, and Tiwari, have dominated the market of investment consultancy and stock prediction. They currently hold 78% of the market share and have been doing so since the establishment of the Devanlok Stock Exchange. Therefore, with Irish Investment Strategies entering as a new competitor into the market, the consumers would be given alternative choices for these services instead of only being limited to the 3 respondents. And therefore, it would increase the competitiveness of the market and ultimately would benefit the consumers.
Okay, please go ahead.
If Your Lordships do not have any further questions, I would like to move to the next prong of my argument, that the appellant has not violated Section 4 of the Act.
Yes, please.
Now, the appellant submit that Patel Data does not hold a dominant position in the relevant market, which is the sale of aggregated index data in the territory of Devanlok. A dominant firm is described as one that holds a position strong enough in the market to operate independently without any concern for other market forces. The guiding principles under Section 19.4 of the Act must be considered, which include the market share, countervailing buying power, and entry barriers into the market. Now, I would like to draw the bench's attention to the case of Dr. L.H. Hiranandani Hospital. Here, the CCI issued a clarification stating that market share and market power are only few of the factors to assess dominance and cannot be used as a decisive criteria for the same. Further, the strength comparative to competitors must be considered, and even if there is one other firm that has the ability to apply competitive pressure, the CCI must take this into account. Furthermore, there must be competitive restraints in the market, including countervailing buying power from not only the present, but also potential competition. When there are few customers, when the consumers are in form of few enterprises with small size and lacking funding, there is no exercise of countervailing buying power. Now, applying the principles of the aforementioned cases to the facts of the present case, although the appellant is a major player in the market, this cannot be used as a decisive criteria to determine dominant position.
Sorry, are you contesting the relevant market or you agreeing with it? The definition of the relevant market.
Your Lordship, the appellants humbly submit that the relevant market for the first issue is the sale of aggregated index data in the territory of Devonlock.
Okay, understood.
What do you think is the nature of the difference between the data aggregation by Patel Data and rest of the firms in the same business?
Your Lordship, the counsel for the appellant submit that the key difference over here is that Patel Data is through the methodology of which they achieve the index aggregated data. Patel Data uses its unique IoT technology, that is the Internet of Things technology, which uses a intricate and complex web of networks to gain and to index and produce this aggregated data, while the other firms in the same use other methods. However, the counsel for the appellant submit that these are substitutable in nature, as the end product as the index aggregated data remains the same that is provided by all the firms in the market.
Sure, thank you.
Your Lordship, the counsel for the appellant requests for 1 additional minute to wrap up the arguments.
Yeah, please.
Therefore, in light of the aforementioned arguments, the counsel for the appellants humbly submit that Patel Data has not violated Section 3 of the Act, as A, there was no agreement between Patel Data and Rich Investments. B, in any case, alternatively, the agreement does not fall under the ambit of refusal to deal. Or C, that in any case, alternatively, it does not have any adversable effect or appreciable adverse effect on competition in the market. Furthermore, the appellant also submits that Patel Data does not hold a dominant position in the market and therefore has not violated Section 4 of the Act. Thank you, Your Lordship, Your Ladyship. It was an honor arguing in front of this court.
Thank you, co-counsel. Good afternoon, Your Lordships and Your Ladyship. I'm the second counsel for the appellant. I'm here to discuss the third and fourth issues in the Honorable Supreme Court of Devonlock, which is whether Aditya Singh Rajput has contravened Section 48 of the Act and whether the Competition Commission of Devonlock has the power to file a criminal complaint under Section 42(3) of the Act against Aditya Singh Rajput for the offences not covered under Section 42(2) of the Act. I will be starting with the third issue and then we'll be moving on to the fourth. Now the third issue is whether Aditya Singh Rajput has contravened Section 48. The counsels for the appellant submit that Aditya Singh Rajput has not contravened Section 48 of the Act. And to prove this, we will be presenting 3 sub-arguments. The first argument is that the appellant, Aditya Singh Rajput, has not satisfied the essentials under Section 48(1) of the Act. Section 48(1) of the Competition Act provides that where a person is committing a contravention of any of the provisions of the Act or of any rule, regulation, order made or direction issued, every person at the time of the contravention who is in charge of or responsible for the conduct of the business of the company shall be deemed to be guilty of the contravention and will be liable to be proceeded against and punished accordingly. The phrase in charge of has not been defined in the Act and can be interpreted in two ways. First, based on the position of the officer during the time of contravention, for instance, the director or partner of the company, or based on authority. Second is through active participation of the officer during the time of contravening act. Now, there are several case precedents that must be noted by your lordships and ladyships. The first would be Indian Sugar Mills Associations, where the Commission held that the penalty will be imposed upon such persons who are in charge of or responsible for the conduct of association while the contravening act was taking place. Swapan Kumar Karak, which is the second case, stated that if the person is not associated with the offending decision, they cannot be held liable under Section 48(1) of the Act. In the Crown Theatre case, even though the President and General Secretary were held responsible for conducting an anti-competitive act, it must be noted that the bench came to this decision after evaluating the role and participation in the contravening act and not based solely on the position that they held in the office. Courts have therefore clearly looked at the role that the individual plays in the contravention as against the position that is held by the person who is allegedly in contravention. Now, if we look at the present case, the appellant was not part of the meeting held on the 28th of February. Due to this, active participation of Aditya Singh Rajput cannot be deduced. The appellant was not present during the time and had also given his voting right to Abhay Singh. The agenda was set much before the 26th of February, and the agenda was circulated. On the 26th of February, Narayan Tiwari and Sarkar Stockbroking came together and asked for a business tie-up with Patel Data, but this was added as an additional point in the meeting, the shareholders meeting that was held on the 28th of February.
So I have a question.
Yes.
Are you dealing with the substantive anti-competitive behavior being inferred to the individual in question, or are you dealing with the refusal to cooperate, refusal to furnish records as demanded during investigation? Which part is this argument?
Yes, indeed, Your Lordship. So this part of the argument will deal with the non-furnishing of documents will be dealt under this fourth issue, which is the criminal complaint filed under Section 42(3), whereas this argument will deal with the former statement that you had made, Your Lordship. If it is permissible, may I go on?
Yeah, continue. I'll come back.
Okay. So as argued above, the court has reiterated that it would look at the active participation of the person and not the position he holds in the firm. It would needed to be proven by the respondents that Aditya Singh Rajput has taken an active role, and his mere position should not hold him liable. Based on the facts, it cannot be proven that he was actively involved, and thus the appellant cannot be held guilty under Section 48 of the Act, unless it is proved. The second sub-argument under this section is that the appellant falls under the exception provided under Section 48(1) of the Act. 48(1) states that if the contravention was committed without the knowledge of the person, he is not liable for the commission of such contravention. In the present case, Aditya Singh Rajput did not have any knowledge about the agenda, of the meeting that was held on the 28th. However, the actions of the three firms took place 2 days before the meeting, and it could not be anticipated by him or the board due to the unprecedented situation of the war in Yashkar, which was the reason why these three firms looked forward to having a business relationship with Patel Data. There is no way to assume that Aditya Singh Rajput had the knowledge to take a vote in this on this specific matter in the shareholders meeting. Therefore, it can be deduced that the alleged contravention was committed without his knowledge, as he was on vacation and his voting rights were assigned to Abhay Singh. The third and final sub-argument.
I have a small question for you.
Yes. Yes.
You've been talking about how Aditya Singh Rajput did not have an active role, and how the courts have constantly looked at not the position held, but the actual conduct. And thereafter, you also spoke about how he did not have the knowledge of such a conduct in the first place.
Yeah.
How has the competition authorities actually looked at such issues for matters falling under Section 48? How have they interpreted as far as the active role is concerned? Do they really look at the active role, or they really look at the position which has been held by these people?
I have indeed, Your Ladyship. So within the case precedents above, it was stated that they will look at the active role in the day-to-day functioning of the company in order to discern the active participation of the person in contravention.
Okay. Okay.
Would it?
But this is where my earlier question comes in. If you're asked to share correspondence with for a period, 1st Feb to 28th Feb, and you simply refuse to share, you refuse to cooperate, how do you then now have the right to say that I didn't have knowledge? If you had shared, the commission may have seen from the record whether you had knowledge or not, whether knowledge could be imputed or not. So why can't it draw an adverse inference that you had something to hide, and therefore now it does not lie in your mouth to say you had no knowledge?
Although there can be an inference drawn, Your Lordship, there has been no specific justification, and there was no allowance for any justification to be provided by the appellant for the non-submission of the correspondences. This is the fourth issue under this argument will be tackling the same. Would it be permissible to go on with this specific issue when we discuss the fourth issue?
Ms. Counsel, is Mr. Aditya Singh Rajput only a shareholder, or does he hold a position in the company?
As per the facts given, Aditya Singh Rajput is a 40% shareholder who also holds voting rights in Patel Data.
I think you must mix the two, frankly. You can't just say I'll deal with it in the third issue and the fourth issue. The same case, the same facts. I'd like to know now, in connection with the fourth issue, what's your answer?
I'm so sorry, Your Lordship. Would it be possible to repeat the question?
So you say whenever I ask you the question about non-cooperation, when cooperation could have actually proven what you're saying now, and an adverse inference could have been drawn, saying that you had something to hide. So I don't see 42 and 48 as being capable of being separated so much. They are two sides of the same coin. So when you say you'll answer it when you come to the fourth issue, I'd like you to deal with it now.
Okay. Indeed, Your Lordship. Through these arguments in issue 3, I would like to substantiate that Section 48 has not occurred. And due to the contravening act of Section 48 not being occurred, the Competition Commission itself cannot file the complaint under Section 42(3). The correspondences that you are mentioning, Your Lordship, we do submit that the correspondences have not been submitted to the Competition Commission as per the Director General's orders. But even if that is the case, there was no specific justification or no time for justification to be provided by Aditya Singh Rajput for the non-submission of these documents. And under the fourth issue, we would be delving into the specifics of that issue, which would mean that due to the fact that the Competition Commission has not allowed for any justification to be provided, it cannot be since it I'm so sorry, Your Lordship. Would it be possible for me to move on to the fourth issue and then discuss the same?
Please do it now.
Yes. So the fourth issue discusses whether the Competition Commission can file a criminal complaint under Section 42(3) of the Act against Aditya Singh Rajput. The first is, as I mentioned before, that the complaint cannot be filed for an investigation into offences that can have not been committed under Section 48. The second sub-argument is with the powers of the Director General, And under this section, we will be discussing section 41, which states that the Competition Act bestows power unto the Director General to investigate any contravention, and they may be able to assist the Competition Commission in by having the powers conferred upon the Commission under section 36(2) of the Competition Act. The Director General will therefore have powers that are equal to the powers prescribed in Section 240 of the Companies Act 1956. And even under Section 240 of the Act, there is only monetary penalty imposed and no mention of imprisonment for non-furnishing of investigative documents. It is stated that the Commission may direct a person to produce books, documents as per the direction of the Director General and furnish it to the Director General. But this document should be regarding to the trade or such other information that may be required for the purpose of the case. Now, if we look at section 36(2), it along with the present scenario, it is stated that it would be regarding the trade. There is no specific assumption that the personal correspondences between Aditya Singh Rajput and Abhay Singh will be related to the shareholders meeting, which is another reason why the non-furnishing of documents in the opinion of the appellant is justifiable.
No, sorry, counsel.
Again,
So it is, sorry, just one thing. So it is for TG to investigate the matter, whether, I mean, by way of these correspondence, any linkage can be established that these guys must have discussed the voting powers, these guys must have discussed something in relation to the conduct, right? So if you receive a notice from the Director General, under what section or under what power you decide not to provide that information? What is your rationale? Did you write to the DG explaining the rationale for the same?
Indeed, Your Lordship. At this point in time, there's no information on the same. So we do not have any information with regards to the actions taken after the notice was provided to Aditya Singh Rajput. But according to the counsels for the appellants, we do believe that Aditya Singh Rajput had the right to justify why these investigative documents were not provided. Additionally, we do believe that the Director General did not have the power to file for a criminal complaint for non-submission of these documents. As presented earlier, Section 240 of the Companies Act in 1956 stated that there's only that the Director General, in accordance to that specific act section, will only have an investigative role and can only impose monetary penalty for the non-submission of these documents.
No, so pardon.
Let us read section.
Sorry.
Sorry.
Go ahead. So, sorry.
No, I wanted to read section 42 together so that we understand your argument. Please have reference to section 42.
Yes, Your Lordship.
Yeah, please see 42.2 and 42.3.
Yes. Yes, Your Lordship.
What are the ingredients?
The ingredients.
What does 42.2 and 42.3 provide for? A person who does not comply with the direction issued.
Yes.
Without prejudice to any other proceeding is punishable. So why would, in the teeth of a request, under the power of a civil court to investigate, you simply refuse to give it? I don't understand why you would say that this section doesn't cover the offense in question.
It is understandable, Your Lordship, but even in the case of Frick India Limited, so sorry. Yeah, in the case of Frick India Limited versus the Union Union of India, it is stated that section titles or headings may also play a role in the interpretation of law. And in case of ambiguity, it was stated that the heading may also be used to provide clarity. Now, if we compare the titles of sections 42 and 43, it's saying that section 42's contravention of the orders of commission is considerably vague in comparison of section 43's penalty for failure to comply with directions of the commission and the Director General. Now we see that through this case, the Director General has taken a wide interpretation of Section 42(3) and 42(2). Due to this, a criminal complaint has been filed, and we believe that this wide interpretation was not necessary for the penalty to be imposed upon Aditya Singh Rajput. Even if there was a penalty to be imposed, it could have occurred under Section 43 of the Competition Act.
Assume for a minute you're right, and we go under 43. Does it then establish that you did not cooperate? And if you
Yes.
did not cooperate, you refuse to provide evidence, why can't I draw an adverse inference for purposes of Section 48? The party has a right to remain silent. If it remains silent, the authority has a right to draw an adverse inference. Which is why I was asking you under issue 3. Why would this not reasonably come within the ambit of 48? In the light of the controversy over 42.
Indeed, Your Lordship. I understand the considerations that the court needs to take at this point in time. According to the counsels for the appellants, we believe that Section 42(3) was not within the power of, was not a power. The imposition of Section 42(3) was not under the power to for the Director General to impose the specific section, and we do believe that Section 48 has not been contravened by Aditya Singh Rajput. For Section 48,
Sorry, Speaker,
one needs...
just one thing. So who has filed the complaint with the court?
Yeah, that was my question too, because you
Yes.
keep on saying that the Director General doesn't
Yeah.
have a power to file a criminal complaint requesting the CMM of Daspur to initiate proceedings against Aditya Singh Rajput under Section 42(3). But it was the Competition Commission of Devonloke which did the same.
As under the Competition Act, the Director General has been bestowed with the same powers that have been bestowed to the Competition Commission under Section 36. 36, if I'm not wrong. And I would just like to add additionally that for Section 48 in specific, there needs to be an affirmative finding for a person to be held in contravention of the specific section.
Where are you getting this affirmative finding from? What are you relying your argument upon? Does the Act talk about affirmative finding, or are you relying upon any case law?
Would the Lordships give me a period of 30 seconds to clarify with this? Thank you. Yes. So in subsection 2, that is 48 section 48 subsection 2, it can only be invoked after it is found that the company has contravened the provisions of the Act. And since the decision of the alleged contravention has been committed by Patel Data and Rish Investments is pending before the Supreme Court, there's no affirmative finding that the contravention has been committed. Therefore, it's safe to conclude that Aditya Singh Rajput will not be liable under Section 48(2), regardless of him being a partner with respect to his position in Patel Data or director of the firm with respect to Rish Investment Strategy.
No, so counsel, I think the confusion here is that Section 48 will only be invoked once there is a finding against the company, which is under Section 27. What we are actually talking about, or what you are actually arguing, is in relation to a non-compliance done by you, which is during the course of investigation. So the two stage of this entire matter is very different, right? So while you may be right under Section 48 because you may not have an active role for XYZ reason, but that does not take you away from the fact that you are not cooperating with the investigation initiated by the Director General. And of course, CCI has power under Section 42 to initiate a criminal proceeding against the individual or the company who is not particularly complying with its order.
Indeed, Your Lordship. I request 1 minute to just wrap up the arguments that are put forward and provide some sort of clarification on the question mentioned.
All right.
Thank you. I do believe that the Council of the Appellants will be sticking to the arguments that are mentioned under issue 3 and issue 4. I'm not sure if at this moment the Council may be able to provide specific answers to the questions that are posed at this point in time, but we do pray for the following release in this Honorable Supreme Court of Devonlock. First, that Patel Data has not indulged in anti-competitive conduct by not providing essential annex data. Second, the conduct by Rish Investment Strategies is not anti-competitive in the light of the Competition Act 2002. The third is that Aditya Singh Rajput has not contravened Section 48 of the Competition Act 2002 and should not be punished for the same. And the fourth would be that the Competition Commission does not have the power and it is not within its rights to file a criminal complaint under Section 42(3) of the Act for offences not covered under Section 42(2) of the Competition Act 2002. Thank
So
you.
what, according to you, what is your argument? What is not covered under 42(2)? Which part of the two contraventions which invoked Section 42 and the criminal complaint? So which is not, which part of the two complaints is not covered under 42(2)?
So in this specific point, Section 42(2) talks about a person who is without reasonable cause failing to comply with sections with directions under sections 27, 28, 31, 32, 33, 42A and 43A of the Act. In this specific scenario, the Aditya Singh Rajput is in contravention of Section 48 of the Act. So there is a clear demarcation between 42(2) and 42(3). Within 42(3) itself, also there is a demarcation where it states that if any person does not comply with the orders or directions issued or fails to pay the fine imposed under subsection 2. So within our specific case in point, we would be taking the former statement, which is if any person does not comply with orders or directions issued. So there's no specific inference under Section 42(2) as the offense has been the contravening offense is under Section 48 of the Competition Act.
So just one last clarification. So you don't think the fact that you did not furnish documents to the Director General, which were asked of, is not a violation of the orders or directions issued under 42(3)?
I would just request your ladyship to extend my time for 1 minute to give that.
Yeah, so the last 1 minute, please, wrap up.
Yes. So although there can be an inference made through to impose this section, this section is this would be a wide interpretation of this specific section 42(3), and this wide interpretation of the section will allow for criminal complaints, which has a huge effect on the criminal justice system. The reason why the Competition Act itself, or the objectives of the Act, involve a justice relief system for contravening actions in terms of anti-competitive laws. So if this specific interpretation of this law is taken and criminal complaints are filed in this scenario, this wide interpretation will lead to the emburdening of the criminal justice system, amongst others. That additionally, it does a criminal penalty such as this would provide a reduction in the quality of life of the individual in the contravening act, and this cannot be substantiated as the only as in this case Aditya Singh Rajput has not furnished investigative documents. As I've mentioned earlier, the Director General and the Competition Commission specifically does not have the power to impose such a stringent punishment for the same.
All right. So thank you. Unless my fellow colleagues have any other questions, I think we can conclude with their arguments. Yeah, thank you very much.
Thank you. Thank you so much, Your Lordships, Your Leadership, for this opportunity.
Council seeks permission to address the bench collectively as your lordships and make submissions before this bench.
Aren't here, but yes.
Sorry, I'm not sure if everyone can hear him clearly.
Yeah, aren't here, but I said yes. Yeah, could you please? This is speaker 1, T001R, right? So could you please speak up?
Your lordships, if am I audible right now?
That's better. Yeah.
Better, yeah.
Council seeks permission to address the bench collectively as your lordships and make submissions before this bench.
Yes, please start.
Your lordship, this is council number 1 on behalf of the respondents, and I shall be dealing with the first and third issue at hand for a period of 23 minutes, whereas my co-counsel, council number 2, shall be dealing with the second and fourth issue at hand for a period of 24 minutes, and we shall be reserving 3 minutes for any rebuttals or sur-rebuttals that may be necessary. Your lordship, the first issue at hand is whether Patel Data has indulged in anti-competitive conduct by not providing the essential index data. Your lordship, we shall be answering to the positive, and we shall be answering so based on 2 legs. Starting with the first leg of the argument, your lordship, where the council would establish that the appellant has not violated section 3(4)(d) of the Competition Act. Your lordship, it is submitted that from a bare reading of the said section, we understand that it lays down 2 essentials. Firstly, presence of an agreement, and secondly, that such agreement should cause appreciable adverse effect on competition. Your lordship, in the case of British Basic Slag Limited was the registrar of restrictive trading agreement, which was reaffirmed in the case of Hindustan Limited. This case was also relied upon by the opposite party. The conditions that would constitute an agreement were laid down. Firstly, there must be a conduct on behalf of one party that induces the other to conduct itself in a particular way. Secondly, that there must exist an exchange of communication. And thirdly, that such exchange must induce the other party to act in a certain way. If the above is construed in light of the given facts, your lordship, we can see that Patel Data refused to sell the index data exactly at the time when the providers of index data in Yashkar were restricted to trade due to international sanctions. Lordship, at the same time, Rish Investment announced floating of their own mobile applications for trading shares, which is the business of the informants. Needless to say, your lordship, that the focal point is Mr. Aditya Singh Rajput, who happens to have a significant portion of shares, which is 40% in Patel Data, and ownership in Rish Investment Strategies. Moreover, your lordships, ASR, that is Mr. Aditya Singh Rajput, did not produce the required correspondences as directed by the Director General of the Competition Commission, leading to active concealment of material evidence that has the effect of showing existence of an agreement. This substantiates, your lordship, that the objective that all 3 parties are the same, that is to thwart the existing competition in the relevant market and gaining a larger market share for themselves. This substantiates, your lordship, that there did exist an exclusive supply agreement between Patel Data and Rish Investment Strategies. Proceeding further, your lordships, to substantiate
Sorry to interrupt. Did you say there's an exclusive arrangement?
Exclusive
available from the...
Your lordship, the council said there is an exclusive agreement of supply between Rish Investment Strategies and Patel Data.
By which you mean Patel would not supply to anyone else other than Rish.
Indeed, your lordship.
Is that inferable from the problem?
Your lordship,
I thought the charge was that you refused to deal with the 3 brokers, not that you would deal only with Patel Data, only with Rich Investments.
Your lordship, that is what is that is what.
I want to be clear. Just point me to the facts. I want to be clear. Is it the point that they would deal with none other than Rish Investments? Or is it that they would deal with anyone but the 3 brokers put together?
Your lordship, it is a accumulation.
Is it a universal inclusion or a universal exclusion?
Your lordship, it is both. It is accumulation of both the arguments that are laid. Firstly, that there is a refusal to deal under 3(4)(d) of the Act, and this they are doing this because they're in an exclusive agreement. The main essential of Section 3, Your Lordship, the mere reading states that there should be an agreement in the first place. Therefore, Your Lordship, it can be inferred from the very facts and nexus of the case, which the Competition Commission has also relied on, that there does exist an agreement, which is the first essential of Section 3. The second essential of Section 3 under 3(4)(d) is that it should cause an AAEC, that is appreciable adverse effect on competition. With that being established, Your Lordship, that there does exist an agreement, we can now move to the second leg of the argument, where we would substantiate that there is an adverse effect on competition, Your Lordship.
I would just like the council to hold for a little while, just in continuation with that question. So how do you infer an agreement just because of the ownership structure between the upstream and the downstream firm, that is Patel Data and Risk Investments?
Your Lordship, firstly relying on the facts of the nexus that is drawn between Mr. Aditya Singh Rajput being a owner in Risk Investment Strategies and a significant shareholder in Patel Data. Secondly, Your Lordship, relying on the case of British Basic Slag, where essentials to construe an agreement was laid down, which was that there must be a conduct on behalf of one party that induces the other to do so. Lastly, Your Lordship, another case, that is British Airways case, where it was held that unilateral decisions, which in this case is the decision of the board, can amount to an agreement. So based on these three...
So it's refusal to deal or exclusive supply agreement? That was the question, I think.
Refusal to deal, Your Ladyship.
Okay, and do they have a duty to deal, first of all?
We understand, Your Ladyship, that it is a free market economy and every trader has a right to choose who they want to do business with. But Your Ladyship, such business, such choice in this case cannot be attributable to their freedom. They are doing this, for which we'll draw a nexus right now, Your Ladyship. They're doing this to eliminate competition from the market, which is going against the basic objective of the Competition Act.
So has that effect been established? So that's your second limb. So you will be, I think, establishing.
Yes, Your Ladyship. May I proceed with the second leg?
Yeah, please.
Your Ladyship, the second leg is with regards to the adverse effect that is caused in the competition in the market. To substantiate the conduct of the appellant, to substantiate, Your Ladyship, that the conduct of the appellant has caused an adverse effect on competition, we shall rely on the test laid down in the case of Oscar Broner versus Media Print. Your Lordship, this case laid down two essentials of refusal to deal to be regarded as anti-competitive in nature. Starting with the first essential, Your Lordship, which is access must be indispensable for rivals to compete, and failing to supply such access must pose a risk of elimination. Your Lordship, any product can be regarded as indispensable if refusal would lead to complete elimination from the market. Your Lordship's index data aggregation is an essential service for running the apps of the respondents. If such data is not provided, Your Lordship, then the respondents won't be able to continue with their business. If Your Lordships could refer to clarification 6 that was released, the appellant Patel Data is the only provider of index data aggregation by IoTs. Therefore, Your Lordship, if this essential data is not provided to the respondents, it would pose a risk of complete elimination of the respondents from the market. Thus, the first essential of this test is satisfied.
Just one question.
There's a proposition of law, just to assist us in understanding. Suppose a war were to end and sanctions were to be lifted. Then in your view, the requirements in law will change again? They can then refuse to deal?
Indeed not, Your Lordship. The demand is elastic right now, Your Lordship. As the clarification clearly states that they were the sole providers of index data by IoTs. This states that even though the sanctions are lifted, they'll still remain the sole provider of data by IoTs, Your Lordship.
But Mr. Counsel, your earlier arrangement that you had in place before the war in Yashkar broke out also didn't provide you average index data with IoTs. So at that point of time, if you didn't insist on this data of index data being provided on the methodology of IoT, which is exclusive to them, what changes now? Because there are other players in the market who can provide you similar index data.
Your Lordship.
Just let me add to that question. So how do you show the criticality of this index data aggregation from IoTs, whereas previously you were dealing with publicly available index aggregated data, and still your three companies were running their business. So the criticality and the essentiality, because the essential facility doctrine, whether you read section 4 or section 3.4, why are you invoking it? What is the granular difference between the data aggregation through Internet of Things or else?
Your Lordship, we need to understand with the growth of technology and what the Internet of Things constitutes right now. Everything that surrounds us is comprised of Internet of Things. Internet of Things drives data from continuous cycle of these connections, and from there data is derived. This is way more efficient than publicly available data, Your Lordship. And we also have a reputation in the market. We want to provide the best to our customers. And with this growing invent in technology, we want to provide our customers with the best data that we could, which is by way of the Internet of Things data, Your Lordships.
So why didn't you invest and vertically integrate? Because if you thought that it was such a path-breaking technology for data aggregation, why didn't you invest, think forward, because these are dynamic markets, and vertically integrate the way Patel Data and Risk Investments have done, and create your own database from the Internet of Things?
Particularly when you have a 78% stranglehold on the market. You're not some babe in the woods. You're the largest player, and you're pitching it high. You're saying the denial is an existential threat.
Indeed, Your Lordship. Firstly, Your Lordship, that why we do understand that we have 78% shareholding, but it's pertinent to note, Your Lordship, that we do not have the expertise in collecting this data and analyzing. We only have the expertise in using this data, analyzing it to give stock predictions to our customers. That is why only Patel Data can do it, and that is why we are not in a competent position to do such analysis.
So we come back to this, then the same previous question. So prior to this, you were collecting some data which was available in the public domain and analyzing to provide the downstream service, right?
Indeed.
So, and that data was also available from the country on whom now the sanctions have been imposed. So you basically cannot get data from there. But there still seems to be a possibility of creating a database even now from the publicly available data, the index aggregated data. Is there a possibility or not? Does that possibility exist?
Indeed, the possibility does exist, Your Ladyship, but it is pertinent to note again that publicly available data is not as efficient as the data we get from Internet of Things.
Mr. Counsel,
but then can you differentiate between the data what you were getting from the previous suppliers? Were you getting data which was at such a granular level as that is collected from IoT?
Indeed not. Your Ladyship, the data which we used to get, which we used to analyze, was from companies situated in Yashkar. They used to analyze publicly available data. But since Patel Data is specialized in analyzing data, in collecting data through IoTs, which is a much more efficient data, therefore we want to do business with Patel Data so that we can provide the best to our customers.
So don't you see an element of free ridership here, in the sense, the fact that you did not vertically integrate, create those data sets, knowing very well that the technology is moving to IoT, now you're asking your competitor to share that data with you?
Additionally, Mr. Counsel,
yes, Your Lordship.
Did you approach other players in the market who were providing similar service to what you were getting in Yashkar? Is this war your opportunity to free ride on Patel Data, which you weren't doing earlier?
Your Lordship, if I may reiterate the questions posed. Firstly is whether we are acting as a free rider, and secondly, why did we not approach other players? Answering the first question, Your Lordships, that we need to understand, Your Lordships, at the present moment, we are not getting data from Yashkar companies. And this is this freedom that has been given to Patel Data to trade with whoever they want to do business with is not, because it is not a mere rejection. It is pertinent to note, Your Lordships, that the fact that Aditya Singh Rajput holds 40% of the share, and if you could refer to para 12 of the Moot proposition, it says that Mr. Aditya Singh Rajput also wanted to enter the trading market, thereby going into direct competition with us, the respondents. Therefore, this is the nexus that we are trying to draw, Your Lordship, that this was done deliberately to remove all competition in the market, Your Lordships. And answering to the second question posed by the Honorable Bench, we could not approach any other players in the market because Patel Data, as per clarification 6, Your Lordships, is the sole provider of data through IoTs.
All right, please continue.
Much obliged, Your Lordships. So this is the nexus we have drawn, Your Lordships, with regards to the Lordships, with regards to Mr. Aditya Singh Rajput. Further, Your Lordship, this act, the Companies Act goes on to define significant influence as having control of at least 20% of the total share capital of the company and having control of the business decision of the entity. This substantiates, Your Lordship, that in the present matter, Mr. Aditya Singh Rajput had significant control over the affairs of Patel Data, as has been stated, which he exercised and denied the market access to the respondents and refused to deal with them. Therefore, Your Lordship, this refusal was made to remove all competition from the market and by the appellants, and thus no objective justification can be provided for the same. Your Lordship, since both the essentials laid down in the test are satisfied, therefore it is submitted that the main ingredient of Section 3, which is presence of an agreement, and secondly, appreciable adverse effect on competition is present, and therefore there has been violation of Section 3, 4D of the Competition Act. This brings us to the second leg of the argument, Your Lordships, where the Council...
Sorry, just one more very fundamental question. Why are we arguing essential facility doctrine under Section 3(4) of the Competition Act and not under Section 4? The case that the case that you are referring is Oscar Bronner, which is under Article 102 of Treaty of Functioning of European Union under European Commission, which is paramateria to Section 4 of the Competition Act. So have you come across any case anywhere where a vertical restraint for and essential facility doctrine has been invoked?
Your Lordship, with regards to the test that we are relying on, that the Oscar Bronner test, this was held, this was used in the case of MM Mittal versus MM Paliwar developers, as well with regards to Section 3, as well as in the case of IMS Health versus NDC Health, Your Lordship. This was relied by the Commission with regards to Section 3.
Yeah, so IMS Health is also a Section 4 case, right? IMS Health is, you're talking about the European Commission case, right?
Indeed.
Yeah, so that's also Article 102 case.
But Your Lordship, the ratio in the Oscar Bronner test was with regards to Section 3 and how an adverse effect in competition needs to be ascertained. This test lays down essentials for an adverse effect on competition to be ascertained, Your Lordship, with regards to Section 3.
Okay, go ahead.
I think my understanding of my colleague's question is that essential facility doctrine, can it be invoked in Section 4 or in Section 3, subsection 4?
In Section 3 as well, Your Lordship.
In Section 3, there is market power. So you have to, as I said, you have to first establish the criticality and the indispensability of the input in the production chain. Were you able to do that? And second, shouldn't it be only if there is a dominant firm, which is, so you're establishing dominance as well?
Your Lordship, with regards to dominance under Section 4, this will be the second leg of the argument. With regards to Section 3, that there is violation of and the Section 3 under 3(4)D being anti-competitive agreement. The two essentials, as stated in the section itself, is presence of an agreement and having adverse effect. These are the two essentials that we have relied on, which has been established in the previous leg of my argument, Your Ladyship.
Okay. And you're relying on the essentiality in Section 3, subsection 4 also. You did.
Indeed, Your Ladyship, with regards to only causing the adverse effect in competition.
Okay.
Your Ladyship, this brings me to the second leg of the argument, where the Council would establish that the appellant has violated Section 4 of the Competition Act. Explanation A of Section 4 talks about dominant position, Your Lordships, and we need to refer to Section 19 of the Act, which lays down certain factors which can be considered while determining the dominant position in the market. With regards to 19A regarding market share of the enterprise, the Council, to substantiate that the appellant does enjoy a dominant position, the Council would state that the market share indicates the dominance of an enterprise in a relevant market, as was held in the case of United Brands and Hoffman. The courts in a catena of judgment have considered it as a persuasive and highly significant factor for determining dominance in the market. If your lordships could refer to para 7 of the Moot proposition, it is evident that due to the aftermath of the war, Patel Data is the biggest player in the market, as only 2 or 3 smaller firms are present globally. Thus, they have the biggest market share right now. Furthermore, your lordships, clarification 6 clearly says that they were the sole players in the market of index data aggregation by IoTs. This proves that the clause A of 19 stands here. With regards to section 19 clause B regarding size and resources of enterprise, it is further submitted that large size and exclusive resources available to the appellants are also significant factors to determine dominance in the market. To emphasize the same, reliance shall be placed on Prasar Bharati case, your lordships, where it was held that size and exclusive resources are substantial factors to determine dominance in the market. Further, your lordships, with regards to 19C regarding size of competitors, it is evident again from para 7 that the size of competitors are very evidently smaller and only merely 2-3 players are present in the market, that too globally. The lordship, in the
just to help you save time with the consensus with others in the bench, maybe you assume dominance but focus on abuse. Save your time on explaining its dominant, but explain to us where is the abuse.
Indeed, your lordship. If you could refer to 4.2c, that is section 4, subsection 2, clause C, which is denial of market access. If Patel Data is not providing essential data to the respondents, and this essential data is necessary for the respondent to run the basic feature of their app, which is stock prediction. Therefore, they are denying market access to the respondents, your lordship.
That brings us back to Mr. Jain's question. How have you been functioning so far? I mean, is it really essential? Or is it because of the war and the inability to tap these substitute suppliers of data to let you function perhaps differently efficiently that this situation has come about?
Your lordship, this is the pre-war condition. We were relying on companies situated in Yashkar for this essential data that we were getting. Now, since sanctions have been imposed on Yashkar, we do not have access to this data. Therefore, we want Patel Data to provide us with data, provide us with this data. If they are denying this market access to us, we won't be able to exist in the market. That is why that is how they are violating 4.2c of the Act.
But you are in effect agreeing to the fact that their abuse is not permanent, it's just temporary. Or their dominance, for that matter, is just temporary.
Your ladyship, we are not aware when the sanctions will be lifted. The proposition nowhere states that the sanctions are for a temporary period. We do not know about what international treaties or the international application of things are going to happen. So we cannot say that it's merely temporary in nature.
Mr. Counsel, I think that timings are also very essential. In Feb, the war breaks out, and within Feb itself, you file a complaint as well. All along, you were surviving and thriving. In fact, as my learned friend said, you had 78%, you still have 78% of the market share based on the average index data, which is otherwise available in the market. I think it would be worthwhile to go around and tap the average index data available in the market even otherwise. Why just go after Patel Data and knowing fully well that if the sanctions are lifted, you might as well go back to Yashkar?
Your lordship, indeed, the timing is a relevant factor here. During the same time, we need to look that the appellants, as soon as they understood that we do not have the essential data for which, because of which we can run our apps, at the same time, the appellant also announced that he is going to enter the same market that we are in. That is, if trading stocks, your lordship. And they are doing this merely to eliminate us from the market by not providing us with this essential data.
So, counsel, don't you think that you have a better argument under section 4.2e of the Competition Act?
If your lordship, let me just refer to the Competition Act.
Which is basically leveraging your dominant position in one market to enter or protect the other market?
This was the second leg of the argument, your lordship, where we were substantiating that there is, apart from 4.2c, there is also violation of 4.2e.
Okay, okay.
To substantiate on the same, your lordship, we need to understand that there are two markets. Firstly, of stock prediction, and secondly, of trading stock. If your lordships would grant me 2 minutes, firstly to 1 minute to sum up this argument, second to sum up issue 3. Much obliged, Your Lordship. So, summing up my argument, Your Lordship, there is violation of 4.2e as there are two markets, firstly of stock prediction and secondly of trading stocks. So they are leveraging their position in the stock prediction market, as is clear from the facts of the case, to enter in the stock trading market, which can also be substantiated by relying on para 12 of the Moot proposition, which says at the same time, Mr. Arbay Singh Rajput announced that he will be entering into the relevant market of stock trading as well. So therefore, Your Lordship, it is evident they're in a dominant position by relying on the authorities cited. They have done a violation of 4.2c by denying market access, and there's a violation of 4.2e that they're leveraging their position in one market to enter the other. Therefore, Your Lordship, their conduct is anti-competitive in nature.
But Mr. Counsel, how do you establish that in the market of stock prediction, risk investment actually is dominant when you have a 78% of the market?
Indeed not, Your Lordship. In the market of stock trading, we have a 78% market share. In stock prediction, risk investment in such a small time has acquired 25% of the market share, which can be inferred from para number 10, where it says every one of 4 online traders started using risk investment services.
Yeah, but that doesn't make them dominant, right? With 25% market share. Because that's the basic ingredient under section 4 to establish, right?
Your Lordship, the dominance of risk investment strategies would be dealt by my co-counsel. Right now, we are dwelling only into the aspect of Patel data being, nature of the conduct of Patel data being anti-competitive in nature. My co-counsel would be in a better position to answer your question.
Okay, understood.
Your Lordship, may I proceed to the third issue?
Yes, please.
Your Lordship, the third issue at hand is whether Aditya Singh Rajput has contravened Section 48 of the Act. Your Lordship, we shall be answering with the positive, and we shall be doing so based on 2 legs. Firstly, that the appellant comes under. If Your Lordship could provide me with additional 2 minutes to just sum up my arguments.
Sure.
So, Your Lordship, the first leg is that the appellant does come under the ambit of Section 48, Clause 1 of the Act. And secondly, that the CCD, the Competition Commission of Devanlok, only needs to prove its case beyond a reasonable doubt. Your Lordship, from a mere reading of the section, we understand that this section covers people who are in charge of and was responsible for the conduct of the company. Your Lordship, it is evident, and Mr. Aditya Singh Rajput was in charge of risk investment strategy as he is the owner. Further, since he had 40% shareholding, which is a significant amount, he is also liable for the conduct of business of the company. This can be substantiated that his vote was held by dwelling into a major business proposal, which was with regards to the respondents. Therefore, since he is the owner of risk investment strategies and has significant share in Patel data, he is liable for the conduct of business of the company. The council would bring it to the notice of bench the automotive bearings case, Your Lordship, where it was held that even if there exists no evidence to establish lack of guilt, it is unlikely that an individual holding a designation that is assessed in 48(1) will escape liability. Coming to the second leg of the argument, Your Lordship, where the CCD only needs to prove its case beyond a reasonable doubt. This was held in the case of Ambuja Cements Limited versus CCI, where it was held that the Competition Commission only needs to prove its case beyond a reasonable doubt before imposing liabilities on individuals under 48. Your Lordship, the standard of proof to convince the Competition Commission is mere preponderance of possibilities. Your Lordship, in the present matter, the Competition Commission has relied on the nexus as already established, which was that the appellant had announced that he would be floating service of trading shares through online platforms, thereby going into direct competition with the respondents. Furthermore, the appellant holds significant share of 40% in Patel data, and through its proxy voting right by executing MGT 11 form, had voted against the proposal, Your Lordship. This rejection was intentionally done by the appellant so as to stop the respondents and eliminate them out of the market. This is therefore, Your Lordship, it is humbly submitted that there exists substantial evidence to proceed against the appellant under Section 48 of the Act, Your Lordship. Therefore, based on this section, Mr. Aditya Singh Rajput is liable under Section 48.
Okay, thank you.
Much obliged, Your Lordship. It was an honor.
May it please this court, the council shall be dealing with the second issue, which is whether the conduct by risk investment strategies can be considered anti-competitive in light of the Competition Act of 2002. Your Lordship, the council will be dealing with this in the affirmative and based on 3 folds. Firstly, that the Director General has identified the relevant market correctly. Secondly, risk investment strategies is in a dominant position in the relevant market. And thirdly, risk investment strategies has abused such a dominant position. Starting with the first fold, Your Lordship, Section 4 of the Competition Act deals with abuse of dominant position. Dominance cannot be assessed without delineating the relevant market in which dominance will have to be assessed. The cyclical manner in which dominance has been defined under the Act makes relevant market a prime determinant in analyzing the realm of Section 4. It is humbly submitted before this court that the relevant market is a market which has goods and services that are interchangeable and substitutable by the consumer for their intended use. Your Lordship, in the case of MCX Stock Exchange versus National Stock Exchange of India, the Competition Commission of India effectively delineated different sectors of the stock market and did not club the other sectors of the stock market in arriving at its determination. Similarly, stock market prediction and investment consultancy form one sector of stock market, whereas managing clients, sharing financial news forms another sector. There is no relation or substitutability between these sectors. Stock market prediction and investment consultancy are done with the help of index data and the same with the help of index data aggregation, which makes it an essential commodity for this market. This can be seen in para 19 of the Moot proposition, where the CCD in its final order says that index data aggregation is an essential commodity for the stock market prediction and investment consultancy services. Your Lordship, stock market prediction and investment consultancy has similar characteristics that are substitutable services which can be taken through apps or through stockbrokers, and its end use is mainly for the consumers to be able to buy and sell their shares profitably and invest wisely. The market for stock prediction and investment consultancy consists of both online and the offline channels. Your Lordship, if both traditional bricks and mortar businesses and internet businesses are included, then markets are delineated much more broadly than in areas in which only internet businesses exist. In the case of Ashish Ahuja versus Snapdeal and another, the court said that online and offline markets differ only in terms of pricing and discounts, but these two markets are different channels of distribution but form a completely same relevant markets. Therefore, Your Lordship, the DG has identified and delineated the relevant market correctly as the market of stock prediction and investment consultancy in the given case, Your Lordships. Moving on to the second fold, Your Lordship, which says that rich investment strategies is in a dominant position in the relevant market, it is humbly submitted before this court that rich investment strategies is dominant in the relevant market since it has the ability to operate independently of the competitive forces in the relevant market, and rich investment strategies affected its competitors, consumers, and the relevant market in its favor. In the instant case, Your Lordship, in order to ascertain that rich investment strategies has the ability to operate independently of the competitive forces prevailing in the relevant market, the factors under Section 19, subsection 4 should be considered. These factors include market share of the enterprise and the size and resources of the enterprise. In the case of Hoffman La Roche versus Commissioner versus the Commission and Neeraj Malhotra Advocate versus Deutsche Post Bank Home Finance, it was held that market shares indicate the dominance of an enterprise in a relevant market. Courts consider it as a persuasive and highly significant factor for determining dominance. However, Your Lordship, contrary to this common presumption that only more than 50% market share can create market dominance, in the case of Fast Track Call Cap Private versus Ani Technologies Private Limited, it was held that market share of more than 50% leading to a presumption of dominance cannot be accepted, especially when the scheme of the Act does not specify any numerical threshold. Applying the same, Your Lordships, seeing that rich investment, despite having 25% market share, can exist independently in the market since it does have significant market power and stands next in line in the market after its three major competitors, which are the informant entities, its market share cannot be seen in isolation for assessing dominance. It is humbly submitted before this court, Your Lordship, that Rich Investment Strategies is the leading stock service provider in the present time, since the informant entities are not able to provide stock market predictions and investment consultancy due to war situation that is being faced in Yashgarh. Additionally, Rich Investment has a strong aggregate index data provided by Patel Data, which is its strongest resource, whereas its competitors have lost their source of the same data as a result of the war in Yashgarh. In light of this, Your Lordship, it is submitted that Risk Investment Strategies was dominant in the relevant market in terms of its size and its resources and its ability to exist independently without its competitors. Your Lordship, in the instant case, Risk Investment Strategies has affected its competitors and consumers and the relevant market in its favor by first selling its service for free, and then as soon as there was a ban in Yashgad and its competitors were rendered helpless, it seized this opportunity and started a new pricing mechanism for its services, which was comparatively cheaper from the monthly subscription of the apps of the Narayan, Tiwari and Sarkar Stocks partners. This led to creation of barriers for the competitors. In light of the above, it is submitted that Risk Investment enjoyed a dominant position in the relevant market. Moving to the third fold of the argument,
Sorry,
which
Council,
is that
Council, just one thing. So you said at 25% market share, they are dominant, right? Is this your argument?
Your Lordship, could you please repeat? Your voice broke in between.
No, I'm saying with 25% market share, you are arguing that they are dominant.
Indeed, Your Lordship.
Any other case that you can cite where a market share of less than 40% has held to be dominant by any competition commission of India? Sorry, by any competition authority worldwide?
Your Lordship, as of right now, the Council is unaware of the same. However, if you would give some time to the Council, I would surely like to get back on this authority. Right now, the Council is unaware of the same, Your Lordship.
Sure. No problem. Go ahead.
So my one more question I have, a follow-up question, Council. So you are owing the dominance to the fact that it has some unique ownership of certain resources which are not available to the competitors and not being made available to the competitors, if I get that correctly?
Indeed not, Your Lordship. The Council is trying to contend that Risk Investment Strategies is dominant because, first of all, right now, since the informant entities are not able to get the data that they need to provide for their services, now they won't be able to function in the market, and Risk Investment Strategies will function very effectively as they stand next in line after its competitors. So when its competitors are not in the market.
Right. So that was my point. So you are saying basically they have some access to such a unique resource, which due to the current circumstances, the competitors do not have that access. And that unique resource is perhaps the data collected through IoT services. All right. So, but my question to you is, again, the uniqueness of that resource, the replicability of the resource, and the time for allowing time which could take for the replication of that resource.
Your Lordship, the uniqueness of the resource lies in the IoTs that are being used by Patel Data in order to provide them the index data. And however, it can be seen that the replicability can be done, but by publicly available data which is in the market. But the same cannot be done as effectively as it would be done maybe by the companies of Yashgad, which was done before, and now by Patel Data, which is done in the current time, because Yashgad is not in the picture as of right now. So
but
even though there
that
is
brings us back to the same question. You were not using IoT data for index aggregation prior to the sanctions on the firms in Yashgad. How does the uniqueness of that IoT data come into being post sanctions?
Your Lordship, your Ladyship, this comes into picture because as of right now, as we know that there's a lot of uniqueness in the IoT data, and the competitors are not being able to provide their information sufficiently and efficiently in the market. Now, Risk Investment Strategies will be able to provide the same information with much better efficiency. This market is very elastic, and as we saw that the moment everything shifted to online technology, people started trading directly in the market, because of which the competitors as well as Risk Investments also started their online apps. Now, when we see that the market demand is moving so elastically, when at that time, if Risk Investment is providing such efficient services alone because of the uniqueness of the data that it is getting, it will result in elimination of the competitors completely from the market, because the consumers will completely move towards Risk Investment Strategies. They will choose that substitute more than the informant entity substitutes, Your Lordship.
Would it be complete elimination, Ms. Counsel? Just because you
Pardon?
don't get the average index data with IoT, would it be complete elimination, or would it affect your ability to some extent?
Your lordship, right, as of right now, as we can see from the facts, if we don't get the data, if we don't get the data that we need to supply in the market, that we need to keep our services in the market, we will be completely eliminated from the market at some point, because rich investment strategies will take over the whole market by giving its services efficiently, because of the uniqueness of data that it is receiving. We will not we won't be able to surpass the costs of that they will be bearing at that time. We won't be able to afford those services as well, because we won't have services through which we'll be earning our own income. So, and additionally, we do not know when the bans will be lifted, your lordship. If the bans are not lifted, it will result in first disruption of the market, and then disruption of the working ability of the competitors, and finally it will lead to elimination of the competitors from the market, your lordship, because rich investments will take over the entire market. We are not sure if we will be able to survive in the market by the time we are able to get the data that we need, your lordship, and that will result in our elimination and rich investments taking over its dominant position and abusing the same, your lordship.
So, but you said that Patel data has got other competitors as well, right?
Your ladyship, there are just 2 to 3 small firms available globally. There's not a lot of firms that can provide data as efficiently as Patel data
And how
to
do you
the
define
competitor.
efficiently? Are you only relying on the IoT feature again and again, or how else are you defining efficiently? Why can't they approach
Indeed,
other? Right. Yeah.
Your ladyship, the proposition and the clarifications clearly state that IoTs are very unique in nature, as well as Patel data is the sole market player in terms of IoTs, and that is why it is very evident from this fact that it is giving very efficient index data to rich investment strategies. Similarly, when you're analyzing the same thing through publicly available information, it won't be that efficient, because IoT is something very new and very efficient, as has already been mentioned. That is how the council is contending that the efficiency in the service provided by rich investments and the competitors will differ, your lordship, your ladyship.
Would that mean, Miss Counsel, that the service you were providing without IoTs earlier was inefficient service?
Indeed not, your lordship. Even before this IoT service came into the picture, we were providing very efficient services that we were getting from Yashgad companies. However, your lordship, right now, that data that we were getting was from Yashgad companies, and how they were collecting that data, the Moot proposition is silent on the same, your lordship. But they were giving us very well collected data, which was giving us the ability to provide efficient services in stock market prediction and investment consultancy. As of right now, we don't have that in the picture. Additionally, your lordship, we don't have the data that Patel data can also provide to us in the picture. So we don't have any means.
Would you say that more than efficiency, the test is it existential? Can you do business without it? Is it in a manner of eliminating your existence? And if the answer to that is one way or the other, what's your submission on that?
Your lordship, this will
And
lead to
another
our elimination.
question. Sorry, sir, just hear me out. One more question. If there's a denial to you, motivated by rich investments' desire to compete with you, would we take it that there's a desire to deny it to others also, the remaining 20 odd percent who are competing with you? Because Rish wants to compete with them as well.
Your lordship, as of right now, from the proposition as we understand, that in Devanlok there are 4 firms operating. 3 are the informant entities and 1 is rich investment strategies. The market share between the informant entities and rich investment strategy as of right now is divided into 75% and 25% in the online market.
Would that be right? You are 78. So someone is 22.
Your lordship, in the offline market, initially they had 78%, but in the online market, when we look at the shares that they have, it is 75%, and 25% is with rich investments. The same can be seen by relying on Moot para number 10 of Moot proposition, which is on page number 4, which says that by 2021, user base of rich investment strategies were significantly increased around every one of the 4 online traders using its services. So when we can see that there's a clear division of 75 and 25% between rich investments and the informant entities, if this is what is happening, the rich investment is next in line. So if we are not able to provide our services efficiently, people will automatically substitute to them, which eventually we won't be able to trade in the market and will eliminate us out of the market, Your Lordship.
Just one point of clarification, but correct me if I'm wrong. My understanding is you define the relevant market as online, offline as one.
Indeed, Your Ladyship.
Yeah, but now your argument is shifting towards the online market. So conduct is in the online market. The definition is online, offline. So do you see a disconnect?
Indeed, Your Ladyship, with respect to the offline market perspective, as well, if we were to assume that there are 22% other players in the market,
shouldn't the relevant market be, therefore, online market should be a separate relevant market, not just a mere difference in the distribution channel? Because I think you quoted Snapdeal and other old orders of the commission.
The citation that the council quoted, in that they said that online and offline are just substitutable channels and they have to be considered in one relevant market, Your Ladyship. So
do you agree to that? Do you maintain that and agree with that even now, given the fact that 8 years have passed between that order and now when this conduct is being under question?
Indeed, Your Ladyship, the reason for the same is that even right now, there are existence of stockbrokers and offline markets available for the same services. So even if we were to assume,
and you don't see the online market as a distinct market?
Indeed not, Your Ladyship. Both of them combined form one relevant market according to the council's argument, Your Ladyship.
But then your leveraging argument will also break down.
Your Ladyship, coming to that, if we were to presume that, if we were to, from the given facts, if we were to say that there are 22% of the offline traders as well, even if they are denying them market access right now, if they're doing that, they're also eliminating those 22%, because the Moot proposition is silent on how that 22% is working in the market. Right now, where we're looking at is from the informant entities side and from the appellant side. So in this case, because of the conduct of the informant and of the appellants, informant entities will be eliminated from the market, is what the council is trying to contend. The 22% of the offline traders, there is a complete silence on this regard as to how they are trading in the market. Therefore, making any assumption about their would not give the council an option to identify how they are working in the market and how they would get affected by the appellant's actions, Your Ladyship.
Right. Please continue.
If your Lordship, much obliged, Your Lordship. Moving further in the argument, there is predatory pricing being done by rich investment strategies. The reason for the same is that rich investment strategies has abused its dominance by violating section 4 subsection 2A of the Competition Act. This can be evidenced from the fact that it has engaged in predatory conduct by committing predatory pricing to eliminate the informants out of the market. This can be seen in para number 4 of Moot proposition, in page number 4 of the Moot proposition, where it is seen in para 9 that in 2017, rich investment strategies started selling their services for free, started giving out their services for free. And until 2022, that is until the war in Yashgarh, they were still giving it for free. After that, around the same time of the war, they announced that they will be charging a certain price on their services, which is still lesser than the prices that the informant entities are charging, Your Ladyship. In such a case, this amounts to predatory pricing. The same was confirmed in the case of MCX Stock Exchange versus NSE, where Commission held that zero pricing, which is adopted by NSE, was a clear method of leveraging done with the intention to impede future market access to potential competitors and foreclose existing competition. In this, it was said that it is completely unfair from the competition perspective. The claim of penetrative pricing will fall apart by even if the appellants claim that they are a new entrant to the market and they're doing just to enter the market. It can be understandable only for an initial few months. In the case of MCX Stock Exchange, NSE was providing free services for 3 years. And the same was held that for 3 years, it will not be acceptable as a reflecting strategy it will be considered as a reflecting strategy for market capture, which herein in this case, the same thing Rish Investments is doing, your lordships. They are
That
giving
was
out
predatory
free.
pricing. That was predatory pricing. This is an inferred
Indeed, your
refusal to
lordship.
deal.
Ms. Counsel, what's the relevant market that you're defining for predatory pricing? And how do you say Rish is dominant in that market?
Your lordship, the relevant market is the market of stock prediction and investment consultancy. This is exactly where Rish Investment is also dominant as of right now. The council is trying to say that that Rish Investments is conducting predatory pricing in this market by providing these services free of cost when the informant entities are charging for the same services. So when they're doing it for zero pricing for 5 continuous years, they are trying to capture market power, because as has been established in the case of NSE versus MCX Stock Exchange, giving services free for 5 years for 3 years cannot be considered as something done in order to penetrate the market, your lordship. Similarly, in this case, Rish Investment has done it for 5 years, and there is no objective justification for doing it for such a long period of time, where slowly consumers will start substituting to Rish Investments. And as seen by the war situation, eventually all of the consumers will go to Rish Investments instead of coming to the informant entities.
As you said, that the stock prediction market offline and online is one market. In the offline market, because the app that you have is only for the broking services, in the offline market, as we can see, you have a larger share and you haven't lost or ceded market to Rish Investment. So would it still be valid to say that there is dominance of Rish Investment and therefore predation, even if maybe we should be saying it is penetrative pricing because they haven't been able to dislodge you even after such a long time?
Your lordship, the offline market, as can be seen from the Moot proposition in para number 8 of page number 3, with the arrival of new online technology and ease of market trading, more individuals started to trade directly into the market. Now, what happens is, even if we consider the offline market right now, the informant entities will not have that much relevance in the offline market, even though there are offline services present. There's not elimination of offline services. And with the coming of online markets as well, if Rish Investments is taking over the entire online market, there will be almost no to nil amount that the informants can earn from the offline market as well, because now mostly everybody is using online markets.
Ma'am,
so
can I request you, if you could mold your answer in the light of the law? Let's come to section 19 and show us from the ingredients of the law. Otherwise, these are economic theories we can discuss in vacuum. In terms of the provisions of law, make good your argument.
Your lordship, in section 19, subsection 4, there are certain elements given which can show that an enterprise is enjoying its dominant position, and those elements that have in order for that, it can be all or any of the following factors. The council in this case has taken market share of the enterprise, size and resource of the enterprise, size and importance of its competitors, and economic power of the enterprise, including commercial advantages over competitors. When you look at this case, your lordship, in these first 4 points, market share of the enterprise, as has been established, market share alone should not be seen in order to assess dominance. As of right now, Rish Investment has 25%, and slowly, when the informant entities are not able to provide the services, it will eventually increase. Moving on to the second point, your lordship, size and resources of the enterprise. the enterprise dish investments right now is in a in that position where it is able to trade in the market. It is not getting eliminated from the market. Additionally, it has a very important resource of its data collection, which is Patel data. Because right now the informant entities do not have the kind of source that they need to provide their services. Then there is size and importance of its competitors. The competitors, even though they were dominant in the market before, where they had majority market share, right now they're completely rendered helpless because of the war in Yashgarh. So when there is a war in Yashgarh and they're not able to trade in their services, they are rendered helpless. So this size of the competitors will go down. Size and importance will also go down, because now people will start substituting with risk investment strategies services more than the competitors services. Fourthly, your lordship, when it comes to economic power of the enterprise, including commercial advantages over competitors, as of right now, risk investment strategies has the biggest commercial advantage over the competitors, the informant entities, that it has the main and the most efficient data which is required to provide stock market prediction and investment consultancy. So when they have such a huge advantage over its competitors, they will be able to eliminate the competitors and be dominant in the market, your lordship. Your lordship, if you could just provide 2 minutes for me to sum up this argument and then move on to issue 4.
Yes, please.
Much obliged, your lordship. So summing up issue 2, as has been contended by the council, Rich Investment Strategies is committing predatory pricing and is enjoying its dominant position in order to eliminate the informant entities out of this market. Moving on to if your lordships are satisfied with issue 2, may the council proceed with issue 4.
Yeah.
Much obliged, your lordship. Issue 4 says whether the Competition Commission of Devanlok has the power to file a criminal complaint under Section 42, subsection 3 of the Act against Aditya Singh Rajput for the offences not covered under Section 42, subsection 2 of the Act. The council will be dealing with this in the affirmative and based on one fold. Your lordship, in the recent judgment of MS Rajasthan Cylinders and Containers versus Competition Commission of India, the Delhi High Court has discussed the jurisdiction and power of the Competition Commission, particularly in light of these two sections. It was held in this section. Before going to what was held in this section, the council would like to read the section before this honorable bench, if that may be permitted.
Yes,
Please go ahead.
please go ahead.
Much obliged, your lordship. So section 42, subsection 2, Section 42, subsection 2 says that if any person without any reasonable cause fails to comply with the orders or directions of the commission issued under section 27, 28, 31, 32, 33, 42A and 43A of the Act, he shall be punishable with fine, which may extend to rupees of 1 lakh. Moving further, section 3, subsection 3 says that if any person does not comply with the orders or directions issued, there's a comma in between, then there's or fails to pay the fine imposed under subsection 2, he shall without prejudice to any proceeding under section 39 will be punishable. Now
So
coming to
council, just one question. So here, which section are you invoking? I mean, the opposite party has contravened which section by non-compliance?
Your lordship, opposite party has contravened section 48. Aditya Singh Rajput has contravened section 48 by not complying with the orders of the Director General, and additionally he has also abused his power in rich investment strategies and Patel data and made them contravene section 3(4)(d) and section 4 of the Act, your lordship. So he has been in contravention of those sections and he's been the cause of contravention by the companies as well.
48,
And
Ms. Council,
additionally, he
is
has also
48 is for a different purpose. Non-compliance
40,
with the
48,
direction is non-compliance with the
thing, yeah.
direction is a different section altogether. And there has been no
indeed,
penalty under section 43 upon Mr. Aditya Singh Rajput.
Apologies, Your Lordship. The council wanted to say instead of section 48, he's also not ordered, he's not complied with the order of the DG by providing correspondences. When he was asked to provide correspondences, he failed to comply with that order. And because
Yeah,
of that,
so
the section
council,
was
just one
initiated
thing.
against him.
So council, under what section the DG can ask for those documents?
Your Lordship, the DG can ask for those documents under section. Just a minute, Your Lordship. Your Lordship, under section 36, subsection 2, the Commission will have the power to receive evidence and to recover and to require the discovery and production of documents,
Yeah.
Your Lordship.
So the opposite parties have basically violated this provision, right?
Indeed, Your Lordship.
Right. Now, if you come to section 42, subclause 2,
Indeed,
there
Your
are only certain category of orders that can be held punishable. Do you see the section that you just quoted in section 42, subclause 2?
Indeed not, Your Lordship. This section is not mentioned.
Yeah. So under what power then you are invoking this particular section? At the threshold, do you believe that you can file a criminal complaint, or even if you can impose for non-compliance? Because section 42 subclause 2 does not deal with this particular fact.
Indeed, Your Lordship. Coming to that point, the power of the Commission in the case of MS Rajasthan Cylinders versus Competition Commission of India, in the regard of these two sections, it was widened in the judgment of this case. In this case, it was held that the use of a comma and word or between the two parts of a clause makes the two parts disjunctive. As when the council was reading section 42 subsection 3, there was a comma in between orders, which the council would like to reiterate that if any person does not comply with the orders or directions issued, comma, or fails to pay the fine imposed under subsection 2. So there is a disjunctiveness created under this section, and this section with this judgment, the powers of the Competition Commission is broadened, Your Lordship. So when you apply the literal rule of the section, and when you see that with that disjunction, the powers are widened, where they can charge for any other disobedience or any other non-compliance, we can clearly say that the same has been done by Aditya Singh Rajput, because as has been established, he has contravened the order of the DG. Additionally, he's also contravened other provisions in the Act, Your Lordship, which is section 48, and he's been the cause of the abusing of dominant position by Rish Investments and Patel Data, as has been argued, Your Lordship.
Counsel, what is your stand on the arguments taken by the appellants that Aditya Singh Rajput had no active role to play as far as the Act is concerned? What is your stand with respect to that?
Your Ladyship, the council would definitely not agree with such a stance that Aditya Singh Rajput has no involvement at all, because first of all, when the shareholders meeting was being held in Patel Data, he had appointed a proxy, and proxy's powers are very limited. When the proxy does something for the person who gives him proxy, he has to inform the person who has provided him with that proxy as to what is going on and under what reason has such a decision been taken, and he has to get an answer from the person who's given him the proxy. The proxy will not by itself take any action. It has to be with the knowledge of the person who has originally given him the proxy. So Aditya Singh Rajput, being a 40% shareholder in Patel Data, he will have some sort of say and knowledge about what has happened. And in the case of Rish Investment Strategies, Your Lordship, he's the founder of the company. He is the one who's founded the company. So it can be clearly understood that when his company is doing something, it will be with his knowledge. The company will not do anything when it is not directed by him, being the
So
owner
you're
of the
relying on
company.
the assumption that he knew about everything. You are basically relying upon the assumption, right?
Your Lordship, the council would not call it assumption, because it can be inferred from the fact that he had given proxy and the fact that he is the director of the company. So that is the council's contention, Your Lordship.
Okay.
Do the facts state that Aditya Singh Rajput was the director?
Your Lordship, Aditya Singh Rajput was the founder of the company, and he
In
becomes
Patel
the
data.
facts are
In
tallied.
Patel data.
Oh, no, he was not a director in Patel Data, Your Lordship. He was just a 40% shareholder in Patel Data. He was the founder of Rish Investments, and he was a 40% shareholder in Patel Data.
So would every shareholder fall under Section 48?
Your Lordship, every shareholder will not fall under Section 48. It is mainly the person in charge of the business. However, if someone's name appears again and again in a case where such a contravention is alleged, he will be considered under Section 48, Your Lordship, because he has a significant influence in the company, having 40% of the share. This was also held in the case of Alchem Chemical Limited versus Axo Chemi, Your Lordship.
Then my learned colleague, Judge Mishra's question to you is correct, that your allegation is based on an assumption just because his name is coming in the complaint again and again.
Indeed not, Your Lordship. This is not something which has come out of just any assumption. The fact that he did not provide any correspondences, the fact that he even appointed a proxy for himself, all of these things, and the fact that he is the owner and the founder of Rish Investment Strategies, with all of these facts, it can be inferred that he had knowledge of the things that were happening even when he was on a vacation. And there exists a principal agent liability between a proxy and the person who gives him the proxy. So when this liability arises, he will be the proxy will inform him about everything that is going on, Your Lordship. And additionally, the 40% shareholding that he has in the company is a very significant share. So when he has such a significant share in the company, it can be ascertained that he will have an active role in the company as well. So that is what the council is trying to contend, Your Lordship.
Okay, I think you can conclude. I think you're already beyond your extended time.
Much obliged, Your Lordship. If your Lordships are satisfied with the arguments, the council would now like to move to the prayer.
Yeah, go ahead.
Much obliged. Wherefore, in the light of the issues raised, arguments advanced, and authorities cited, it is most humbly prayed that this honourable commission, this honourable court, may be pleased to adjudicate and judge and declare that Patel Data has indulged in anti-competitive act by refusing to sell and abusing its dominant position. That Rish Investments has indulged in anti-competitive conduct by abusing its dominant position. That Aditya Singh Rajput has contravened Section 48 of the Competition Act 2002, and that the Competition Commission of Devanlok has the power to file a criminal complaint under Section 42, subsection 3 of the Act against Aditya Singh Rajput for the offences not covered under Section 42, subsection 2 of the Act, and as such, the order of the High Court of Daspur be upheld, and pass any other order in the favor of the opposite party that this honorable court may deem fit in the interest of justice, equity, and good conscience. Thank you, Your Lordship. It was an honor arguing before this court.
So thank you. I think now we can just concur as a bit.
If the bench has no other query for any of the teams, I would request on my direction that the live broadcast be stopped for this meeting and the teams to stay back and remain logged in for feedback in case the bench does have any. Ma'am, I would request, ma'am, sir, everyone in this meeting, I would request everyone to stay here but not currently engage in any discussion. I will be confirming that the live stream has stopped, and thereafter we shall be proceeding to deliberation on scoring and feedback. And before we proceed to anything else, the rebuttals and sir rebuttals, please.
Your Lordship, Your Ladyship, the counsel for the appellants solicits permission to proceed with the rebuttals.
Yeah, 2
Please
minutes.
go ahead.
Yeah.
Much obliged, Your Ladyship. The council would like to make two rebuttals. First is pertaining to the agreement, the anti-competitive agreement of Patel data. The respondents rely on the argument that there was an agreement between both the parties. Even if we are to take the respondents' arguments at its best in isolation to all the rebuttals provided, this best case scenario fails